Good morning, this is your Kelso Report for Monday, September 19th, and I'm your host, Clark Kelso. Well, our featured case today has an in-bank panel of the Ninth Circuit overruling one of its own 25-year-old precedents, and in the process, striking down under First Amendment grounds an anti-solicitation ban enacted by the city of Redondo Beach in its effort to combat day laborers who, at two major Redondo Beach intersections, congregated on a daily basis and interrupted the flow of traffic while they tried to get jobs for the day from passing motorists. While waiting around these intersections, these same men were alleged to commit acts of vandalism, litter, and urinate near the businesses in the area. 25 years ago, the Ninth Circuit faced a virtually identical ordinance which had been enacted by Phoenix, which provided that, quote, no person shall stand on a street or highway and solicit or attempt to solicit employment, business, or contributions from the occupants of any vehicle, close quote. The court upheld that ordinance in Acorn v. City of Phoenix in 1986. 6 months after the Acorn decision, Redondo Beach enacted its ordinance that bars individuals from standing on a street or highway and soliciting or attempting to solicit employment, business, or contributions from an occupant of any motor vehicle. Shortly after a particularly effective enforcement effort in 2004, the plaintiffs, two day laborer organizations, filed suit to challenge the ordinance on First Amendment grounds. The district court granted a preliminary injunction to the plaintiffs and found in their favor after cross motions for a summary judgment. A three-judge panel of the Ninth Circuit reversed, holding that the case was controlled by the Acorn decision. An in-bank panel was then convened, and in its decision, 9-2 on Friday, in Comité de Jornaleros versus Redondo Beach, the Ninth Circuit overruled its decision in Acorn and struck down the Redondo Beach ordinance. The key steps in the majority's analysis were that the solicitation was clearly protected expression under the First Amendment. Public streets and sidewalks occupy a special position as a public forum for expressive activities, and the ordinance was not narrowly tailored under the time, place, and manner test applicable to public forums. According to that test, reasonable restrictions on time, place, and manner must be narrowly tailored to serve a significant governmental interest and leave open ample alternative channels for communication of information. The court agreed with the plaintiffs that there were many examples of types of speech prohibited under the ordinance that do not cause the type of problems that motivated its enactment. The court gave as examples children selling lemonade on the sidewalk in front of their home, Girl Scouts selling cookies on the sidewalk outside of their school, sign bearers on sidewalks seeking patronage or offering handbills, even though their conduct does not pose a traffic hazard, as well as sidewalk food vendors. It would apply even to school children shouting "car wash" at passing vehicles, as well as protesters imploring donations to a disaster relief fund. In summary, the court concluded the ordinance was significantly over-inclusive and therefore not narrowly tailored. Chief Judge Kaczynski wrote a truly impassioned dissent, and one with which I find myself in agreement. The primary target of his dissent is the majority's failure to give the ordinance an appropriately limiting interpretation that would easily avoid constitutional difficulty. For Kaczynski, it was easy to interpret the ordinance's focus on soliciting as essentially meaning efforts by the day laborers to actually cause cars to stop to engage in bargaining about work for the day. He cites a dictionary definition in support. As for the examples given by the majority, he points out that they are really quite improbable and unrealistic. As he notes, quote, the judicial imagination can always run wild in conjuring how laws can be misapplied, but the Supreme Court instructs us that the mere fact that one can conceive of some impermissible applications of a statute is not sufficient to render it susceptible to an overbreadth challenge, close quote. Kaczynski concludes that, quote, the majority is demonstrably, egregiously, recklessly wrong. If I could dissent twice, I would, close quote. Chief Judge Kaczynski's dissent is going to draw the attention, I think, of the Supreme Court. So I wouldn't be surprised to find this case on the court's docket in the coming year or next. And now our one-liners. We begin with an anti-SLAPP case. In Tuzinka versus Cunningham, the 4th District held that the selection of outside counsel by the Riverside Sheriff's Association Legal Defense Trust was a protected petitioning activity, which made the plaintiff's claim that the defendant discriminated against women in the selection of counsel subject to the analysis of California's anti-SLAPP statute. The court rejected the argument that the defendant's selections of counsel were unprotected conduct, explaining that for purposes of the anti-SLAPP statute, it was inappropriate to artificially separate defendant's communicative conduct from alleged discriminatory motive that rendered the communication unlawful. The two things need to be considered together, and the anti-SLAPP statute therefore applied to the Legal Defense Trust's allegedly discriminatory hiring decisions. Next, in the area of family law, in Neil S. versus Mary L., the 4th District held that a man who claimed to be the biological father, but who could allege none of the facts to support a claim to be the presumed father, such as spending time with the children after their birth, lacked standing to file a petition to establish paternity when the mother and her husband were married at the time of conception, and the husband had immediately accepted the children as his own, thereby establishing himself as the conclusive and presumed father. The court also rejected the petitioner's constitutional claim that his alleged status as biological father gave him standing as a matter of substantive due process. That argument had previously been rejected by the California Supreme Court in 1998 in Dawn D. versus Superior Court. Next, a class action case in Ellis versus Costco Wholesale Corporation. We begin to see the fallout from the United States Supreme Court's decision earlier this year in a Walmart Stores versus Dukes, where the court tightened up the analytic requirements under Rule 23A for maintaining damage class actions. The district court had granted class certification in a class action brought by 3 named plaintiffs who alleged that Costco's promotion pack practices discriminated on the basis of gender. This was similar to the claim brought in Walmart. The Ninth Circuit vacated and remanded most of the determinations made by the district court for reconsideration in light of the Walmart decision. I do think it will take a couple of years for the Supreme Court's Walmart decision to work its way through the district and appellate courts. The first step will be reconsideration of decisions. After that, we'll have to see what type of reception Walmart receives in the lower courts, whether it really takes hold or whether the lower courts try to find ways around the decision. Next, in the area of health law, in California Association of Medical Product Suppliers versus Maxwell Jolly, the 1st District upheld regulations issued by the California Department of Healthcare Services in 2004 that established an upper billing limit for reimbursement through Medi-Cal of purchases of durable medical equipment and certain other medical supplies. The regulations require providers to bill Medi-Cal based on the lesser of the usual charges made to the general public, or, alternatively, the net purchase prices of the products as documented in the provider's books and records, plus no more than a 100% markup. The plaintiffs claimed the regulations were beyond the department's statutory authority and were issued in violation of the Administrative Procedure Act. The court rejected both of those arguments. Next, in the area of occupational safety, in United Association Local Union 246 versus the OSHA Board, the 3rd District reiterated its holding in Overall Construction versus OSHA Board that the Division of Occupational Safety and Health may issue citations to one or more controlling employers at a multiple employer worksite without having to demonstrate as part of the prima facie case that the controlling employer was in a position to abate the violative safety condition at issue. Instead, the issue of whether the employer has the ability to abate the violative condition can only be raised by the employer as a defense. On the prima facie case, the division need only show that the employer is contractually responsible for safety and health conditions at the worksite. Abatability is a defense. Next, in the area of remedies and strict products liability in Bailey versus Safeway, The First District held that a manufacturer of a product found to be defectively designed cannot seek equitable indemnity against a retailer whose fault is based only on the same product liability theory. The issue arose in a case where the plaintiff was injured in a Safeway store when a bottle of Cook's champagne exploded as he was erecting a sales display, and the cork seriously injured his eye. He sued both the champagne manufacturer and Safeway. The manufacturer settled with the plaintiff for $1 million, plus assignment of the manufacturer's claim, if any, for equitable indemnity against Safeway. Trial proceeded against Safeway, and the jury found Safeway was not negligent, but was nevertheless liable on a strict product liability theory. The plaintiff then sued Safeway for equitable indemnity. The district court rejected the claim on demur, and the appellate court affirmed, noting that it could not find any case authority which would allow the manufacturer of a defectively designed product to obtain equitable indemnity against a retailer who did nothing more than offer the product for sale. Given the jury's finding here that Safeway was not negligent, the manufacturer had no basis for suing the retailer for equitable indemnity. Finally, in the area of public employment, in Chan versus Judicial Council of California, the Second District held that licensed court interpreters do not have a protectable property right in continued employment, and that the Judicial Council could therefore impose a new rigorous certifying exam and require all existing court interpreters to pass that exam to remain as court interpreters. The court explained that the relevant statute expressly provided that the Council had discretion to adopt certification procedures, and because of that statutory provision, along with undisputed evidence that the Council did not guarantee to the plaintiffs indefinite employment as court interpreters, the plaintiffs did not have any due process rights in continued employment without successfully completing the appropriate certification procedure. The court also rejected a very weak equal protection claim, challenging the Council's decision to certify as court interpreters a small number of interpreters who actually designed the certification test without requiring them to take the test they had themselves designed. The equal protection challenge failed, since those few interpreters were clearly not similarly situated to the rest of the interpreter community who had not participated in designing and drafting the new certification exam. You don't make the teacher take the test. And that's it for today's Kelso Report. Have a great day in the law.